And good afternoon, everyone. Thanks for joining us. My name is Jeremy Schwartz. I'm joined by my partner and friend, Ryan Conlin, and we're going to beat this dead horse one more time, I think. And we had a little discussion about this presentation before we decided to announce the webinar about whether we're one too far, we're being too optimistic, but we both hope that this is the last time we have a program where the meat is about COVID and the road back. And hopefully the next time we meet, we can all be talking about general employment law and health and safety related concerns. So without any further ado, I'll launch into what is sort of my introduction to this program on the area that I'm going to be covering. And sorry, what is going on here? I've got too many computers and too much going on. There we are. All right. So mandatory vaccination policies. The last few webinars that we ran, we were dealing with litigation primarily in the unionized area where it's easier for employees to bring complaints without asserting things like constructive dismissal. And so although that law wasn't necessarily applicable outside of the unionized sector, in our view, and I think as we expressed multiple times, the law on the human rights aspect as interpreted by the arbitrators really is no different, or the law on the privacy concepts really is no different in the unionized context on this topic. And so the issues, as they would be outside of the unionized context, is the employer promulgating a policy that's lawful? Has that employer created a policy that is reasonable and addresses the issue that is before the employer? Do we have a concern that the employer has a legitimate interest in addressing in its policy? And then finally, has that policy been trained for employees? Has it been crafted in such a way where it does infringe on employees' rights so as to be minimally infringing and only to address the policy objectives? And we had a number of cases dealing with this. In some situations, we had employers that introduced policies where they were in highly safety sensitive fields. In particular, safety sensitive in the context of COVID, of course, means that you have vulnerable either staff or client or patient populations in the medical sector. And so there was an enhanced need to have as much protection as reasonably possible. And the vast majority of arbitrators in that context were prepared to err during the heat of the pandemic on the side of precautions. And so even where things like mask mandates or vaccination mandates were not necessarily scientifically proven in the early days, arbitrators were prepared to allow for more enhanced PPE and other protocols and precautions on the precautionary principle, the idea that the science is developing, but it does appear that doing this or doing this will enhance protections for the employees or for the people who interact with the employees and the community. And so we're going to permit certain policies to be promulgated. Now, there's an issue, of course. Anytime you have a policy that says you must do something or must not do something, the consequences set out in the policy as to what happens when you violate that obligation are sort of critical to determining whether the policy is a reasonable one. And we had a case in January of this year, which may be probably the beginning of a number of the sorts of cases we're likely to see as things progress, where we're going to find that arbitrators in the courts and the human rights tribunals are less willing to sort of rely on that precautionary principle, particularly when it comes to vaccination policies. And so in this particular case, the adjudicator held what constitutes a reasonable mandatory vaccination policy in the course of a pandemic. And this is a policy in this case which provided that employees who did not get vaccinated would have either unpaid leave for a period until they got vaccinated or ultimately terminated for cause. The pandemic is contextual and highly dynamic. In such an environment, both the overall circumstances in the community and the circumstances of the particular employer take on a great significance, while precedents decided in a completely different context, and in this case, even as recently as November of 2021, necessarily become less relevant than they might otherwise be. And so I think in one very long paragraph there, two very long sentences, the arbitrator has summed up what I believe to be the new lens through which all policies to do with COVID and the consequences written into those policies for non-compliance, more importantly, will be viewed. And so what we need to keep in mind when we're crafting these policies is that they must be regularly reviewed as the pandemic and as scientific knowledge and as government directives evolve. And so now that, as of March 1, for example, in Ontario, a number of precautions have been altered or being changed, and there's discussion about further alterations of various precautions and requirements in terms of government mandates. Now is a good time to have a look at your policies, which, while they might have been reasonable in the past, may no longer be considered reasonable if they're applied and there are consequences visited on employees going forward. So what we have, of course, is the end of vaccine passports for other COVID mandates in Ontario, both at the federal level when it comes to transportation, flying and things like that, but also in general, requiring people to show vaccine passports in order to go into restaurants is abating across, that requirement is abating across the country. Mask requirements are going to be changing, other things like this. And so it's possible that that will come back. If there's a resurgence or if a new variant is identified that's more virulent or more dangerous. But ultimately, we've seen sort of 2 years of this progression, and one hopes that now that we've reached this phased reopening and we're at the point where these precautions are abating and the requirements are being removed to follow these precautions, that's not going to go backward. And if it doesn't go backward, there is a live question for a lot of employers which had a stronger policy or requirement to be able to justify consequences like unpaid leave or like termination for cause for people who don't comply with the requirement to vaccinate. If at large, the government is no longer requiring that either through public health directives or regulation. Changing gears a little bit, we have a number of cases which we've spoken about, and I'll take you through a few of them in a moment, dealing with how temporary layoffs during COVID have been treated. So in general, when you have a layoff and you don't have the right in your contract, either expressly or implicitly with that employee, not just with others or in a policy, to allow you to temporarily lay off an employee, even if it's done in accordance with the minimum requirements of the employment standards legislation where you are situated. And in Ontario, there are certain limits. That's the way we've done it here is there are limits to how long a temporary layoff can go built into the ESA, but nowhere in the ESA does it expressly say that employers have the right to lay off. And so there have been a significant number of cases that have dealt with this where employers have assumed that they had the right to impose temporary layoffs, and this is long before COVID. This has been a significant issue for many employers, and they learned the hard way that imposing a temporary layoff on an employee in respect of whom you don't have the right to impose a temporary layoff by contract is a constructive dismissal, and an employee in that circumstance has the right to either object to the layoff immediately or to live with the layoff for a brief period of time before determining whether or not to accept the employer's action as what would be considered a repudiation of the contract and so claim constructive dismissal. But in any event, a lot of employees were prepared in the beginning of COVID when layoffs were being implemented to wait and see because it was a scary time, no one knew what to do, and these were being implemented as layoffs because we didn't yet have any statutory or other mechanism for calling it anything else. Then comes the infectious disease emergency leave, and every province took a slightly different approach. Some took a similar approach to Ontario, but in other provinces, in fact, the vast majority of provinces, rather than introducing an infectious disease emergency leave that would do what we have done here in Ontario, which is to convert what would otherwise have been a layoff under the statute, under the Employment Standards Act, into a leave of absence protected under the statute, infectious disease emergency leave. Other provinces like Alberta simply extended the period of time where layoffs could continue without triggering a permanent layoff, and so a termination of employment. So here in Ontario, 13 weeks, if you do have the right to lay employees off, 13 weeks in a period of 20 triggers a permanent layoff, which is a termination. In some cases, where you have a collective agreement or where you continue to make substantial payments or continue benefits, for example, for the employee, you may have the right to continue a layoff for 35 weeks in a 52-week period. That's sort of the standard temporary layoff definition in Ontario. But obviously that was not going to be enough. The government, on the eve of what would have been the 13-week threshold across the province in Ontario, determined that this is likely to be a more long-standing situation, that a lot of employees were going to end up having their employment terminated by statute, even if the parties didn't intend that to be the case. And so the government stepped in really at the 11th hour, introduced infectious disease emergency leave, which deems a layoff which is temporary, which was introduced because of COVID, and that's critical. That has to be the basis or the reason to support the layoff being introduced and continuing. The layoff is converted under the ESA to a protected leave of absence. There's no obligation to continue benefits unless you've agreed to do so in your contract or policies. The critical issue, though, and we warned of this when COVID first started back in March and up to April when this IDEL came out, is that the statute does not expressly say, and neither did the IDEL provisions when they came in, that anything about this means an employer has the right to implement one of these leaves or layoffs, which are converted to a leave in the first place, going back to the case law on how layoffs are treated under the common law versus how they're treated under the statute. And now the government has kicked this can down the road multiple times. We're well beyond 35 weeks in a 52-week period at this point. The leave started in, I believe it would have been April of 2020, and it's IDEL as a concept is not due currently to expire until July 31st of this year. So they have pushed that deadline many times, 4 or 5 times at this point, and it's possible that they'll push it again, but one hopes that we're at a point in the transition back that that's no longer necessary once we get to the end of July. Now, a few cases came up to deal with this statutory and common law tension, or perhaps there's a lack of tension, a lack of clear tension, and the government did not address this in their legislation. So we had one case, Catino, where the court went through a very detailed analysis of the provisions, but ultimately what the court found is that the provisions in the Employment Standards Act are expressly not there to modify your civil or common law rights unless they say so. And so any right that an employee has to bring an action under the common law is not removed solely through the fact that there's an employment standard to deal with that term and condition of employment in the statute. And so in Catino, the court found that, again, going back to when IDEL was created, the government did not expressly say common law rights are removed here. And as a result, a layoff, even if it's converted to an IDEL leave of absence, still began life as a layoff. And if the layoff is a violation of the employment contract at common law, an employee can bring a termination case before the courts as a wrongful dismissal or constructive dismissal action, and they can be compensated under common law. Under Fogelman, which was a case which was decided soon after that, essentially said Catino was rightly decided, and the court said at the time that the employer's actions in refusing to pay out the employee's statutory entitlements, which is an interesting ironic twist because of this constructive dismissal, was in fact, and a number of other misconduct the court noted, which they felt was deserving of some sort of punishment. They exposed this employer to a damages award of punitive damages in the order of $20,000. So not only was this employer wrong by implementing this layoff, which was a leave that the statute said they were allowed to, or in fact obliged to implement if they don't have enough work, and the reason is as a result of COVID, it is IDEL, it is a protected leave. Nonetheless, Coutinho said that was a constructive dismissal, and Fogelman said not only is it a constructive dismissal, but failing to pay out someone's statutory entitlements upon a constructive dismissal was grounds for punitive damages. Finally, at the same time as Fogelman was released, the case of Taylor was released. So Taylor and Fogelman are both Superior Court decisions in Ontario. They're at the same level in terms of the levels of courts deciding things, but Taylor did not have access to the Fogelman decision and vice versa when those courts were deciding those cases following Coutinho. So Taylor expressly found that Coutinho was wrongly decided. Taylor specifically found that the purpose of introducing IDEL was to prevent terminations of employment, was to protect employers from being hit with wrongful dismissal lawsuits where COVID was the basis for the layoff, and in particular, in a number of situations, the layoff or the loss of work, the ability to provide work to an employee, which causes the leave or the layoff, was because the government had implemented a shutdown or required the employer's operations to cease because of COVID. So in that circumstance, what the court commented about was simply how can an employee claim constructive dismissal when in fact what we're dealing with is essentially a government caused or mandated loss of work, which the government itself has classified as a leave of absence, which is protected under statute. So what the court in Taylor said was, this is not a layoff, this is a protected leave of absence under the statute, and therefore it cannot trigger a constructive dismissal. So you probably can guess where this is headed. Taylor is on its way to the Court of Appeal, and so we don't have a decision yet on an appellate level on this issue. Obviously, one hopes that the majority of folks who were off on a leave of absence, an IDEL leave, have been returned by now, although it's possible they haven't been yet, and we may see some situations going forward where people try to claim that the leave that they've been on for a very long time is in fact a constructive dismissal. I will say that constructive dismissal is a wrongful dismissal claim like any other, where an employee has an obligation to mitigate. Now, in some cases where you claim that you've been wrongfully or constructively dismissed, the employee has to object within a reasonable period of time to the actions of the employer. So while Coutinho and Taylor and Fogelman are cases which were arising out of early days IDEL leaves of absence, up to 6 months or 9 months after the initial layoffs took place, if someone were to bring a claim at this point, it's likely that the employer would have a strong argument, at least in my view, that the employee has implicitly condoned or accepted that an IDEL leave can continue. And the only caveat to that would be if the employee has consistently said, you don't have the right to lay me off, but I'm going to continue on this layoff in order to mitigate my losses by not claiming a constructive dismissal at this point, so that I can get a recall when you're finally able to recall me. That employee might still be able to claim constructive dismissal or damages for loss of work, but most employees, I think, would have a pretty difficult time making that argument. Now, don't forget, even though we're moving quite close to the end of hopefully the pandemic's worst effects and the leave of absence itself under the statute, that as with all statutorily protected leaves, if you've taken the position that an employee is off on a statutory protected leave, like IDEL, you have the same obligations to reinstate them. The employee has a right legally to their job if it exists, or to another job if their job does not exist. And the courts are very clear, and so is the labor board, about what does it mean for a job to exist. So I know this has been a very long time since some of these leaves may have started, but the courts have and the labor board have made it very clear that if you've got a job that's made up of 5 functions and there wasn't enough work to occupy 5 or 6 people, and so what you did was you took those 5 functions of one individual's job and divided it among their coworkers, and then that individual went off on a leave because there wasn't really enough work to occupy them at the time. When that leave is over, you have an obligation to take those functions back from the folks that it was delegated to and reconstitute their position. And so if the work that was sufficient to occupy them now exists, if you took it back from those various people, you now do have an obligation to reinstate them. Their job does exist, and you can't take the position that there's no longer sufficient work. You'll be found to have committed a reprisal and to have violated the employee's right to be reinstated following the leave. Now, COVID has had a marked and substantial effect on a lot of employers and their operations, and it may be that entire divisions no longer exist. It may be that there really isn't enough work to reinstate that person or their position, and in which case you're going to have to potentially justify your actions in not offering that person their position or an alternate position if theirs no longer exists. So it will be important to document your thought process. It will be important to be able to show objectively their job does not exist, and that you are not essentially committing a reprisal against them because they took that leave by failing to reemploy them when their leave is done. Consequences for committing a reprisal, failing to reinstate someone following a leave, may be that they are reinstated. Not only that they are reinstated, but they may be reinstated with back pay to the day that the court or tribunal finds you could have reinstated them to employment. They may be entitled to general damages for pain, suffering, and humiliation, and they would also be entitled to any compensatory loss flowing from the failure to reinstate in a timely way. And so there is a significant risk to choosing or taking the position that you can't reinstate someone to their job or offering them a suitable alternate job. So you want to think very clearly about this and not just shoot from the hip about why it is you don't believe their job still exists. Now, I don't want to be all Chicken Little about this. The sky is not falling. If the position and alternate positions no longer exist as a result of normal changes or changes occasioned by COVID, you've had to change the way you do business or how you operate in certain areas, that's not going to take away your right to say, we don't have a job for you, and so your employment comes to an end. And so this off-cited statement from Ayed will, I think, still be the law. It has been consistently the law for the last 10 years. A statement by the Labor Relations Board here similarly has been stated in various ways and iterations for the last 10 years since that case was decided. These provisions, the ones requiring reinstatement, do not impinge upon employers conducting their businesses in the normal course. Therefore, a returning employee cannot insist upon a former position unaffected by legitimate changes in the business operations that other employees have been expected to accept. So if there have been changes, they have to take it as they find it when they come back to their job, nor expect the employer to freeze the employee's duties in perpetuity if the changes are dictated solely by the requirements of business. So not only do you not have an obligation to bring people back if there is no job, but it may be that the job you return them to has changed, and there is an obligation for them to accept a reasonable offer where the changes are reasonably to be anticipated, especially if other employees have had to shoulder similar changes because of COVID or any other normal operating considerations. So how do we avoid claims in this area when we're dealing with IDEL? Keep employees updated. I assume you have been because you've been joining us for the 5 or 6 webinars where we've talked about this. You want to lay off to expiry with agreement if you can, but you want to regularly review to ensure that COVID remains the reason why their layoff has continued. So you might have been very clear because of lockdowns or some other reason in terms of your ability objectively to demonstrate that the layoff or leave began because of COVID, but has it continued for 2 years or more because of COVID? Again, at a certain point, if an employee were to claim that the leave came to an end when it was no longer related to COVID, they may be able to assert you have an obligation to reinstate them. And if you have an obligation to reinstate them, that the obligation arose whenever it was that the work was available. And so if they were to claim a reprisal by your failure to return them, they might not just claim failure to return full stop, they might claim a failure to return in a timely way and seek retroactive damages for the time they should have been working. You want to ask for severance volunteers. So if you know that you're unlikely to be able to bring someone back, eventually their employment is likely to terminate, you will have to pay at a minimum their statutory entitlements. It's possible you'll be able to take a position they have no common law entitlements, but that's a technical argument that really depends on the circumstances. So ultimately, you may want to give employees a little bit more than their statutory entitlements in exchange for a full and final release, and to make that voluntary. It needs to be voluntary, but there's no law that says you can't say to employees, you know, we have 10 people in this department, we probably only have enough work coming up for 5 of you. Can we get any volunteers who would like an enhanced severance package? And we're prepared to discuss and negotiate that with you so that we can exit and bring your coworkers back sooner. You want to secure agreements for partial or modified returns. So if you do have work, it's just in a different area, and you don't want to have to hold out that individual's job that was pre-leave after you return them to modified or partial duties, you want to put that in writing. So if you bring someone back to a job that looks different or has a different position, you need to have an understanding in writing about whether that is what the parties agree constitutes the fulfillment of the employee's right to reinstatement, even though it's to a different position or to different duties or somehow otherwise modified, or if this is simply a temporary measure and the employee is reserving their right to be reinstated to their pre-leave position. This is something you'll have to discuss and put in writing. You may be able to require an employee to return, similar to the analysis in the IED case. If you don't have their current position and it's unlikely that's going to return, you have some other position or modified position to return them to, you might be able to argue that returning them to this alternate job is the recall they're entitled to, and that if they refuse to return under that modified role, that they're declining or they're refusing a reasonable offer of alternate work, and so your obligations under the statute are fulfilled, and that's the end of it. That may in fact disentitle them to even their employment standards minimum notice and severance entitlements, but I wouldn't take that position without speaking to counsel. And finally, keep track of your records and reasons. You want to ensure you can prove it, because again, the onus is flipped and the employer must show that the leave had nothing to do with the reasons why the employer no longer has the ability to return that individual following their leave of absence. Now, on the common law side of things, we have seen some decisions where the courts have said that a notice period under the common law, which again is determined on a number of factors, age, length of service, how difficult it will be for the employee to find a job in the current circumstances. The courts have said that if you terminate someone, you give them working notice during the pandemic, while we still have these government shutdowns and other restrictions underway, they may be willing to look at evidence that it was more difficult for the employee to find a job, and so they may enhance the notice period that they otherwise would have awarded the employee subject to mitigation. Now, of course, it's very important to keep in mind that mitigation is something that happens or that is assessed at the time. So you need the circumstances in order to know how they're going to, how the pandemic and the circumstances will affect whether or not the employee is entitled to anything in particular. And so while COVID may increase notice, where it can be shown it's affected the employee's ability to find this replacement employment, the amount is very difficult to assess in advance. And you must keep in mind that employers in wrongful dismissal litigation, they bear the onus of proving the employee has not taken reasonable steps to mitigate, which is an awfully high burden to establish, and which unfortunately primarily is done by saying to the employee in the discovery phase, give us all your evidence of your attempts to mitigate. So what we've been doing since time immemorial at our firm is where we have an employee who would likely have a significant wrongful dismissal claim, as in many months of potential notice damages, rather than relying on the employee's efforts and then pointing where it looked like they didn't appear to be taking reasonable steps to mitigate. We'll actually recommend that our clients assist the employee either by providing them at the employer's cost with access to reemployment services, to assist them with resume writing and applications and the like, or to actually send them copies. The employer should be looking actively, or having someone else out there actively look for opportunities that appear to meet the skill set and experience and salary expectations of the employee, and sending them copies of those applications, and then we use that in discovery, and we say, okay, well, so the 3 months after you claimed that you were dismissed, the employer sent you these 5 applications and recommended you apply. Did you apply? And if the employee says no, that's fairly elegant evidence that they have failed to make reasonable efforts to mitigate. So feet to the fire. Don't let them get away with just arguing generally, well, it's COVID, it's very difficult to find a job. The reality is we have a labor shortage these days, and there are a lot of employers that are looking for employees, and that the employee cannot say that, well, COVID, therefore I can't find a job. They really do have an obligation to actively look for work, and if they don't meet that obligation, then there will be a set-off by the court of the number of months that it felt the employee could have shortened that unemployment period if they had gone looking reasonably for that work. All right, so I'm going to turn over the mic to my friend Ryan Conlin, and he'll take it to the end.
All right, thank you, Jeremy, for covering that ground. And we're hoping it's the last time we hear the words IDL and layoffs and such, but I guess we're at the point where the rubber's hitting the road on that topic. I'm moving to a different phrase, one that is, I think, somewhat timely in light of the apparent or hopefully end of the pandemic. And that's the returning to the office. And that's dealing with those of you who have employees who are working, have been working from home throughout the pandemic, and the time has come, and we're starting to even anecdotally see in Toronto that the subway's a little more busy, the train's more busy, the streets are more busy, that people are starting to come back to work. And so, but obviously there's going to be some employees, now that we've been dealing with this pandemic in excess of 2 years, we're sort of coming up on the 2-year anniversary of when all the restrictions went in place and everything, the world changed in March of 2020. So what do we want to do? What if there are employees that want to stay home, that basically say, look, I've been doing this for 2 years, I'm as productive as I was, I don't want to commute, gas is $2 a liter, those sort of things. Certainly the problem, of course, is we don't have a lot of case law on telecommuting and such. It's obviously a relatively new concept for most employers. Certainly we have one case from 2018 at the Court of Appeal, which is a factually horrible case for an employer. Really, it was an employer that hired someone to work at home, and that person had been working from home for 17 years. The company's ownership changed hands, and the new management directed this person to come to work, and the employee, not surprisingly, took the position that was constructive dismissal, and the court, that trial and at the Court of Appeal both agreed that that was the case. Ultimately, I think what the case next slide. The case establishes for us is that certainly, if someone's hired to work from home, and that was the basis they were hired to work from home, it is probably going to be in most circumstances a constructive dismissal to return them to. But I don't think there's much else that's really valuable to us here. If we hired someone during the pandemic as a home-based employee, it might be problematic to try to start bringing them back in unless there had been an understanding at the time of hire that the job would be in person when it was safe to do so. What if employees are afraid to come back for fears of contracting COVID-19? Forgive my cynical nature, but certainly there may be some employees that might use that as sort of as a sword to avoid coming back to work for other reasons, whether it's personal preferences and convenience and such. I'm going to touch on human rights issues in a moment and as to how they pertain to this, but a general fear of contracting COVID-19 is not a legitimate basis for a work refusal under the Occupational Health and Safety Act. The Ministry of Labor, Skills Development and Training has decided most COVID-related work refusals, and as long as the employers are complying with the law around the precautions, and those laws are, both, and I'm not referring to the laws, I'm specifically often referring to those municipal and regional-based laws that have been more prescriptive than the provincial government on those issues. Ultimately, if you're getting people to come back from home, gradual steps being taken. The idea that someone's going to be able to just say they have a generalized fear of COVID-19 without something specific to their circumstances is not likely going to succeed. I don't think that someone's going to suggest that an employment contract has been amended because an employee was working from home during a worldwide pandemic. I mean, it was a solution that was steps taken out of desperate times. It was certainly not a suggestion that employment contracts have been amended. Next slide. What about unvaccinated employees who have been remote until this point? Some of you may have some of those people that it's just simply easier to have those folks work from home. The employer has the right to require a return to the office, taking into account any human rights exemptions. And like we have to remember, human rights exemptions to vaccinations very, very limited. I mean, Jeremy and I have covered that ground multiple times on these webinars, but just a reminder, it's disability, it's a legitimate religion or creed-based belief, and like when push comes to shove, we think there's going to be a relatively incredibly small percentage of people that are going to be able to establish and able to establish an exemption. But ultimately, with the province starting to drop vaccination requirements in certain settings, does proof of vaccination amount, does lack of decline to provide proof of vaccination amount to just cause for termination? Undoubtedly, that's going to be a question courts are going to ask some employers, even though it appears that COVID has, the seriousness of it, and the Omicron wave has subsided, that there seems to be a general consensus that the disease appears to be moving towards an endemic rather than pandemic phase. So it may very well be that a court is going to have to obviously consider the question, is declining to provide proof of vaccination just cause? And I think it's obviously going to be a fact determinative situation in the sense that what kind of workplace is it? What kind of, are they dealing with people that are at high risk? Are they not? What is the scientific evidence around the actual risk? We certainly know from, those of you who've been to our webinars will remember very early in the pandemic, Jeremy and I spoke extensively about the influenza vaccination cases, which were and masking policies, which were imposed by hospitals and challenged by unions repeatedly. And certainly, why the employers almost always failed in those cases was a lack of evidence of any of the current benefit of the influenza vaccines, and particularly masking policies. And there may be, as the disease moves on, maybe the employers may start having evidential problems, but and employers are certainly still going to have the the basis to say that being vaccinated certainly prevents the spread of COVID-19, certainly reduces the risk of people getting sick in the workplace, and is for a legitimate purpose. So, I mean, we're just going to have to stay tuned, depending on how, and obviously, it's fact dependent. If another variant comes that makes it more serious, so employers are just going to have to recognize that it may very well be someone who wants to insist on that. And really wants to insist on a mandatory vaccination policy has to be prepared for either a grievance or a wrongful dismissal case if they're going to go as far as termination. I wanted to shift gears, if I can, to I think the issue that's probably more frequently going to come up, and this is the human rights issues around return to work. Some workers may claim they need to be accommodated to stay home from work on the basis of family status. They need to work from home in order to take care of their children. But bottom line is, this isn't a new issue. Certainly there has been a considerable amount of litigation on this issue, and almost all of which revolves around scheduling, though. Usually it's not so much about where these cases historically have not been about so much as working from home, is more frequently about hours of work to reflect the requirement for childcare, elder care, care for other individuals that are incapable of looking after themselves for whatever reason. But obviously, I think we may look at a flurry of employees that have now been working from home for 2 years in some cases, that might argue that, leaving aside the pandemic, that they need to be home for whatever reason. Certainly. And ultimately, where does that take us? I mean, the employer's duty to accommodate remains the same here, right? We're not talking about a COVID-specific right. This is a right that emerges out of family status. The next slide. And I want to be as practical as I can for you. I mean, there's been almost an absurd amount of legal debate between the courts, the various human rights tribunals across the country, and labor arbitrators as to what the exact legal test is, and what and to what extent employees can quote unquote be required to self-accommodate by relying on other resources that are available to them, and how this duty differs from other human rights issues in terms of accommodation and such. I think the bottom line is, though, all those discussions are fascinating to legal academics and lawyers and such. But I think from your perspective, you have to understand that family status has been interpreted to be very broad. It can mean obviously children, but it can also but it can also be based on blood or adoptions, but the ties that are based on care, responsibility, and commitment. So it is incredibly broad. It is incredibly broad. Originally, family status had historically been interpreted to mean basically you're being discriminated against because of who your children are or who you're married to. But in recent times, it's been interpreted considerably more broadly than that. One of the leading cases, one of the most talked about cases in this area is the 2016 decision, Mistitch versus the Value Village retail store, which many of you would be familiar with as sort of a used clothing retail operation. And basically, a quote that came out of it is this was a seminal case that got into all of the legal nuts and bolts about what the actual test should be and things like that. And it just basically says that the quote that's relevant to you, which I think is one of the more practical aspects of the decision, is a workplace rule may be discriminatory if it puts the employee in the position of having to choose between working and caregiving, or if it negatively impacts the parent-child relationship or whatever relationship is at issue, frankly, and the responsibilities that flow from that relationship in a significant way. That being said, employees, like you may get some employees that may decide, well, I want to work from home so I can be there when my kids get home from school. That might be the kind of thing that's not likely going to be considered discrimination on the basis of family status. Do you need to be there when they got home from school? Were you there when they got home from school 2 years ago when they were younger? Is there no way that someone else couldn't meet them when they got home from school? So the line really comes down to there's a significant difference between someone who desperately needs to be at home for whatever reason, and those circumstances may have arisen while they're working at home. And so the pandemic identified that working from home is a potential accommodation. That being said, the pandemic hasn't really altered the test. And the last lesson that comes out of Mistitch is that the employee has to provide particulars and information. Mistitch probably had a good case against Value Village, but lost because she simply refused to provide the details of the problems associated with the elder care situation she was claiming. She basically said, if I claim elder care, you have to accommodate me. And that's not the law. The employee does have to cooperate. Is living with an immunocompromised person enough to sit there and say that, look, I need to be at home because I'm putting that person at risk? It would seem to me, and it's our view, bearing in mind that all these cases are very fact dependent, that given that the Omicron spread is so widespread within the community, it kind of comes up down to, like, when you've heard the discussions about what's the point of testing at the border now, because it's all over the place anyway. What's that possibly accomplishing? Probably, frankly, nothing. Then this is kind of that same sort of situation, that given how widespread that it is, unless you're going to establish that the person is so immunocompromised, you literally never leave your house and then go to the grocery store, don't go anywhere. In most cases, it's likely to be insufficient to warrant accommodation. There may be some exceptions in very serious and specific fact-driven cases, but I'm thinking, given the way Omicron is going and given just how widespread it is, how easily it spreads, it just seems that, it's just different than the other. It's just as different. It's like it's going to have to be managed the same way that other endemic diseases, remembering things like influenza, can be particularly serious for certain segments of the population. In terms of what if the employee has genuine child or elder care responsibilities and requests to work from home, such accommodation may be legitimate, but you got to look carefully at what it is that's being asked to be accommodated. If the employee is working from home, are they working, or are they actually, what they're saying is, I'd like to work from home and look after my children or other vulnerable person while I'm supposed to be working? That's what makes this different than the scheduling cases. That really, at the end of the day, work from home is not an excuse to be paid full pop to work part-time while you're looking after someone else. So, it has to be clearly defined. Maybe the person saying they're working from home because the commute allows, but if they're not commuting, they have additional time to help. But it doesn't mean that there's no law that says that accommodation means you get to fulfill your family responsibilities while you're on the company clock. That's not the case. Next slide. So let's take a look at some practical advice here. Like, I really just wanted to walk through it. I understand, certainly in the employer community at times, there's a bit of eye rolling when this kind of issue arises. It arisen. Some people, there was a mentality historically that, look, you look after your family outside the office. This is the job, do your job. That's kind of historically how some folks have looked at things. That's not the world. You got to take family status accommodation seriously. Failure to do so will result in the Human Rights Tribunal imposing considerable remedies on people. Never use the word self-accommodate. You heard me throw that out there so casually. Self-accommodated, basically telling the employee, you got to figure this thing out on your own. Although you are perfectly entitled to ask why the person can't, like using the example that I want to be there when my kids get home from school. Well, why aren't you able to work out after school care like most of the rest of people that have to work when school ends at 3 and people get off work at 5, kind of thing? What makes your case particularly unique when you can point out there's dozens of other cases in that situation? I mean, you do have a right to request information about an employee's family status accommodation request. That's, as I emphasized, Ms. Tucci made that clear. An employee who just simply says, look, this is my situation without further particulars is not going to succeed at the Human Rights Tribunal, even if their case, might have actually had some legal merit had they shared their situation, which was the mistake the applicant made in that case. So, I mean, the standard question that we can just use is like, are there any other supports or resources for family-related needs available to you that you could help meet the needs of your child or parent? And then it's one of those things that, I mean, the law is really tricky. It's really nuanced in this area. I mean, Jeremy and I encourage you to get some legal advice. Like if you're really trying to make a decision on, well, what should we ought to do about this particular person and what's the, what are the consequences if we're wrong? You want to give us a call because human rights cases can get quite expensive. I mean, by the time the way damages work is employees can get general damages and lost income from the day of the violation to the day of the hearing, which can be literally years. It can be not handling human rights law correctly can be one of the most expensive mistakes where you have employees in some cases getting more money than even the longest service employees that they would get from wrongful dismissal at common law. Next slide. So you want to ask reasonable questions to understand the details of the employee's needs. Like what are the family-based responsibilities? Like they need to say who they are. What is the specific workplace practice or rule having an impact on those responsibilities? Like, why is it that working from home, why do you need to work from home? What specific reason? What is it you're doing? Are you doing these things in working hours? Perfectly legitimate questions. What supports or other resources are available to the employee if there's, community resources, things like that. And if the employee has not used them, why not? And it just becomes down to, and that sometimes may involve, if you're talking about things like elder care and community supports, might require some research on the employer's part to even say to the employee, have you considered this? And if you haven't, why not? Type of thing. Certainly those are some of the practical factors that come in. But I think the point we want to make is that really, it's really basically the same question. The question that you have to bear in mind that employers are not entitled to be doing their family responsibilities, generally speaking, for the most part during working hours. It may, we're dealing with something that's potentially like an emergency situation or something like that. But when you're working, you're supposed to be working. So those are my thoughts on the human rights and contractual issues around the return to the office. I guess we look forward to your questions.
Thanks, Ryan. So we're into the Q&A portion of our program. As it stands, we've got one. If you're not sure how to ask a question, on the right-hand side of your control panel, there should be a little place to enter a question and submit that. If you can't see that, there should be an orange arrow that you should click, which will expand the little control panel, and then you should be able to see the question section, and you can send that in. So I'm going to have a look through these questions, and as they come in, I'll sort of moderate whether it should go to Ryan or I based on whether the questions relate to one of our sections. So this one relates to IDEL, so I suppose I'll take it. Can an employee still take IDEL if they are afraid that their child may contract COVID at school and/or childcare? I understand this was the case earlier on in the pandemic. Is this still a valid reason for taking IDEL? Okay, so this is sort of overlaps, I suppose, between what Ryan and I have been saying. Somebody's subjective fears about things are not going to be the test. The test will almost certainly relate to the objective concerns of the employee. And so if that individual has a child who is particularly vulnerable to contracting COVID, or someone at home would be particularly vulnerable if that child contracted COVID at school and then brought it home, then there might be, in certain circumstances, validity to that concern. If it's just a general broad concern, well, children have been going back to in-person school for many months. They do so following public health protocols. They all wear masks, and they all make best efforts to socially distance, et cetera. And so in the context where the government has essentially been recommending that people send their kids back with those protections in place, I think it would be very difficult for most employees to establish more than a subjective fear, and in which case they don't have the right to argue that they're off on an IDEL leave, or that they're entitled to a family status accommodation in that circumstance either. Um, general question. Oh, Ryan, this may be a good question for you. Any news on the Working for Workers Act and the need for employers to have off-shift hours away from work policies, etc.? Actually, you know what? That doesn't really relate to the program that we've been talking about. I'll just mention very briefly that the government did put those requirements in place to have a policy if you're over a certain size. We did deal with this in one of our updates that's available on our website. The government has not yet issued any regulations specifying what that policy would have to contain. And so for now, employers can either sort of create a policy on their own, hoping that it will meet those requirements, or they can wait for the regulation to come out. The obligation isn't until the end of May to put those policies in place.
Yeah, Jeremy and I had discussed there's a number of issues in that bill, including Bill's significant changes to sentencing and limitation periods under health and safety law as well. So stay tuned. In April, we look forward to bringing you a more detailed review of that rather broad legislation.
So Ryan, here's a question for you. If we've got an employee, here it is. If we've got an employee returning from maternity leave and they're refusing to comply with the mandatory vaccination policy, is that a reason to terminate or not return them from their mat leave?
Well, I mean, the answer is that you're probably they're obviously terminating someone returning from maternity leave sends off all kinds of legal alarm bells, obviously, but so it's not a decision to be made lightly. First of all, you're going to have to actually prove that that you would have fired other people in those same circumstances, that you're not treating this particular person differently, or else they could say that's because you're picking on them because it's a maternity leave. Alluding earlier to the question I said, like what a court's going to do as to whether that's just cause or not is a very fact-driven exercise, but there is a legitimate risk. A court's going to say it's not, that the disease is endemic now, it's not serious, that vaccination it's not, that a lot of the mandatory requirements that used to exist are now gone, that it's a personal private healthcare information. So it's a very legally sensitive and risky area, and you'd want to get some advice before you did that.
Thanks, Ryan. So a follow-up from the individual whose question I answered a few moments ago. Apparently they contacted the Ministry of Labor, and the Ministry of Labor is taking the position that there's no room for determining whether or not it's a subjective or objective fear, which is leading the employee to say that they can't return because they have to be home to provide childcare, and that's a basis for an IDEL leave. I will say two things about that. First, I don't believe that's actually what the state of the law is or will be as the pandemic shifts toward the endemic. Second, I'll say that the folks that you make contact with at the Ministry of Labor when you phone the hotline, nothing they say to you has the force of law, and employers have many times in the past phoned that hotline, been given answers, and either those answers are incomplete or flat out wrong, and they end up finding themselves in the crosshairs of wrongful dismissal or human rights litigation. So take what you hear from the Employment Standards Hotline with a grain of salt. If you're asking anything more complicated than how do you calculate vacation pay and overtime entitlements. But obviously, this is a developing issue, and we have yet to see any litigation on the question whether an employee who asserts they're on an IDEL, so unlike Catino and Taylor, this is an employee who says they're on an IDEL because of a subjective fear that isn't objectively substantiated, whether or not that would be an IDEL and therefore a protected leave under the statute, I suppose is a question for the Labor Board to respond to at some point. So thanks to that attendee who provided that additional information. Excuse me. I don't see any additional direct questions. There are a few questions here asking about whether the slides will be available and whether the recording of the session will be available. The answer is they both will be. Everyone who attended today will receive a survey for feedback on the program, and at the end of that you'll be directed to a page on our website. It's a secret URL that has our slides, and at a certain point in the media center you will be able to find a recording of this presentation. Ryan, we've got another question that's come up that I think would be good for you to tackle. If masking or face covering is no longer required by law, can we still require employees or visitors to use them via our company policy?
Yeah, you know what, you raise a perfectly appropriate question there. It's a good one because I think we're looking at the end of March. That's probably going to be the case that the province isn't going to require it. And you have the right to take all precautions reasonable in the circumstances for the protection of a worker, and have, in fact, have that obligation, not just a right, it's an obligation, Section 25. Sub 2H of the Occupational Health and Safety Act, and in my view, that masking has been considered a proven way of preventing the spread of the disease. And unless someone can identify some legal reason, human rights or otherwise, why they can't wear a mask, it's a private establishment. That's the requirement. It's a piece of safety equipment like any other in that respect.
I think that has to be the answer, doesn't it?
Yeah, I think so.
All right. So I'm not seeing any other questions. We'll give everyone another minute or two to come forward with questions. One thing that I was expecting to see a question, but I didn't see a question on this, so maybe I'll just tackle it myself. There's been a significant amount of confusion concerning the regulatory change that happened in September, which provides that if the Chief Medical Officer of Health in a local area consults with the provincial Chief Medical Officer of Health and promulgates a recommendation that people do something in respect of COVID, have a policy or whatever, take certain precautions in a local geographic area, then you have to comply with that recommendation as if it's a legal requirement. And there have been a number of jurisdictions where the Chief Medical Officers of Health did consult and did promulgate policies or make recommendations or directions of that sort. And so we have yet to see any follow-up letters in those jurisdictions where they're saying that those requirements are no longer in place. And so I think hopefully they remember that they sent out these recommendations and that we all had to follow them. And so as the government transitions and starts removing some of these requirements, that we don't still have to follow these Chief Medical Officer of Health recommendations if they're directly inconsistent with the regulatory change or not, is an issue that may actually come up in the future. So if there's anyone listening here who has the ear of Chief Medical Officers of Health, please remind them that they've made binding recommendations and they should clarify if they still apply. We do have a few new questions that have come up. Ryan, so Ontario government workers, according to Richard Mullen at the Treasury Board, will no longer, this is someone has said that they've, I guess, seen this, will no longer need to provide proof of vaccination or undergo regular testing to go to work as of April the 4th. Have you heard anything about that?
Yeah, I have, and that seems to be. I have to confess, I don't remember what the date was off the top of my head, but yeah, that would seem to be what the general approach is going to be.
Okay.
I mean,
that general requirement will apply elsewhere? Do you think they're going to expand that in terms of the way?
No, I think it's the way. I think it's dealing with the employees of the provincial crown, if I'm not mistaken. I mean, I haven't looked at it carefully, but that had been my understanding of it.
Okay. So to be clear, then, where the government exercises its rights to manage its own workplace, they're not doing so in a regulatory capacity, to the person who asked that question. So if the regulation changes or if the Chief Medical Officer of Health in your region issues a directive, then or takes a directive down, then that's the law for you. If you see the government do something with its own workers, that's not automatically going to be the law for the people living in that jurisdiction.
No, the province didn't choose to regulate workplaces generally under health and safety legislation around vaccinations. They sidestepped that issue.
Yeah. Ryan, is physical distancing out the window now? That's the question. Can employees say it's unsafe to be in the office if we can't socially distance?
I think that that's good. That's going to be a tough pitch to make objectively. The way they could, their practical remedies to issue a work refusal, it's probably not going to be successful. I think because the ministry is just going to take a look at what's gone on elsewhere, like the capacity limits on restaurants and such, and with the end of masking rules. I mean, it may. So I think that's going to be, especially as time goes on, a tough pitch to make. It may very well be that someone could say maybe there should be masking rules where physical distancing doesn't exist. Well, that's still required elsewhere, but that's going to be, as it goes on, that's good. I think it's on its way out anyway, more likely.
So Ryan, if sort of asking a follow-up question there, so you mentioned work refusals. If an employee is saying that it's unsafe to work because we can't socially distance anymore, or in the way that the work is being done, should the employer jump to the work refusal steps in the Health and Safety Act, or should this be handled more informally first and then treated as a formal refusal? Do you have any advice practically on that?
Well, I mean, practically, I think that remember, there's got to be a question, as to whether or not this issue is even covered by the work refusal sections of the legislation. I think I would always encourage you to try to resolve this stuff informally, maybe involve the Joint Health and Safety Committee, all that kind of stuff. But if an employee is actually trying to characterize this as a work refusal, you have to go through the steps. And I think you have to if you can't resolve it, then you have to ask the person, are they invoking their right to refuse work? And then you probably would want to get legal advice on whether or not this is in fact a work refusal, remembering that there are certain rules that apply to certain workplaces around work refusals that vary, right? So you'd want to get some advice on that.
Okay, and then I suppose ultimately, though, from your comment before, if the ministry is brought in to determine whether or not a work refusal is objectively substantiated, nowadays it's likely very difficult for the employee to meet that objectively substantiated bar, and they're more likely to be directed to go back to work.
Yeah, the practical answer is work refusals have not been a particularly fruitful angle for employees to enforce some COVID safety concerns.
To do with COVID, yeah. All right. So I'm not seeing any more questions at this time. I guess we'll give everyone one more minute. We did say we would go up to 1:30 if necessary, but I don't think we need to force everyone to stay online. All right, so not seeing any other questions or raised hands, I guess we'll bring the session to an end. Thank you very much to everyone who attended. Thanks very much to everybody for your very thoughtful questions and for your follow-ups. Those are much appreciated. They certainly add a lot to the conversation for everybody. And do stay tuned. We will have a feedback survey that gets sent out to your email. And once you respond to that, you'll get the slides and be reminded about the link to our program recording when it's done. And keep an eye on our website for additional updates and blogs on topics related to COVID. Bless you, Ryan. And take care, everyone. Stay safe.